lawyers and talked about the defense. The defense has said as follows: we're trying to win at all costs. We only care about winning, not just.
Didn't I sustain that objection?
No, you did not until the fourth time I asked it, Your Honor. I objected 4 times. Let me continue. We suborned perjury, stated 3 times. I objected each time. We could have called the worst of them all. We could have called Haji. The court knows we found out about him that morning. The court made a finding that their discovery violation was not inadvertent. That means it was intentional. That means it was not accidental. They got up here and just told this jury that they didn't hear from this witness Haji, that we could have called him. The court knows we have a hearing about it. It's been very clear. The court found that they were not honest in what they provided. They were not honest about when they actually turned the information over. And now he's up here and able to argue that. And when I object, basically I'm told it's overruled. I mean, Judge, the problem is the court's made these findings. The court said you could not disparage lawyers. Let's be clear. If anything that he had said was true, that we suborned perjury, that we don't care about justice, those are reportable issues to the state bar. The court knows it's not true. I know you know it's not true, Your Honor. I assume he knows it's not true. And then finally, he has repeatedly misstated the standard of reasonable doubt. There is no standard whatsoever where you can say that each one of these are, quote, reasonable doubts. That is not a correct standard. The standard is looking at all the evidence in total. Did the people prove the case beyond a reasonable doubt? It is improper to say, if this fact is wrong, that is, quote, a reasonable doubt. You can argue that that evidence is important enough, etc. So they're misstating the reasonable doubt. But more than that, Your Honor, they're disobeying the court's order about disparaging other lawyers. I object. The court lets it go. Then
Wait a minute. I don't let it go. If I see or I think that Mr. Tacopina is disparaging you or you are disparaging him, I will put a stop to it.
Judge, I objected 4 times. You overruled all my objections. You finally sustained an objection. And when the court sustained the objection, I made clear that my issue was the second part of it, which had to do with they were in essence disparaging both of us. Your Honor, I mean, it's not a hard question. They're saying we suborned perjury 3 times. Your Honor, that's improper. It's misconduct.
I didn't hear that.
What? Your Honor, it's in the record. 3 different times he said we suborned perjury. I don't know what to tell you.
Hold on. Kathy, was that said?
I don't remember.
Your Honor, we said,
All right. If it was said, then I should have stopped it. But I don't remember if it was said. You have made so far 9 objections. 6 were overruled. 3 were sustained.
the problem
So
was,
therefore, what?
the problem was, I believe the first 5 I made were all overruled. The court, Your Honor, I've been in front of this court for 30 years. The court knows who I am. The court knows what my ethics are. I'm not going to sit here and tell the court that I'm objecting when he didn't say it. He said repeatedly we suborned perjury. Your Honor, that statement in and of itself is severe misconduct.
All right. Can you, in the break, can you look, can you see? If that was said, then I'll bring it to the attention of the jury that
Your Honor,
that's an improper statement.
This is what I'm asking. Mr. Tacopina can go after our witness all he wants. He can even misstate the evidence. What he cannot do is he cannot argue, A, why we put a witness up there. He cannot say that we suborned perjury. He cannot say that all we care about is winning. He cannot say that this is supposed to be the pursuit of justice and the prosecution doesn't care about that. He has said all of those things. He needs to stick to the evidence in the case. Either he doesn't know California law or doesn't care. And Your Honor, the court's already found, and the worst of them, and I want the court to instruct, he got up there and argued, why didn't you hear from Haji? The court knows, Your Honor, the court made a finding.
You're repeating yourself.
Well, will the court do something about it? Will the court instruct that that was improper argument?
All right.
Can I respond?
No.
Okay.
Failure to call logical witnesses is permissible. You're going to have a rebuttal argument. You can address it in your rebuttal argument as to why you didn't call it.
Your Honor, this is all I'm asking, Your Honor, and I'll say it. The court knows what happened. we've had many hearings on this, etc. They knew the evidence, they presented it late, they had repeated orders to turn over statements. He got up and said, that's not the statement of the witness. 1054-3 is very clear. What they gave us is supposed to be the statement of the witness. And when he's standing up saying, well, that's not his statement, that was his statement, that's what they had to turn over. So yeah, Your Honor, I can go back and I can go and argue in the court and say, well, it's just both sides are arguing. But Your Honor, there are rules for a reason, and we follow them. You have not found one instance in this case, not one, where the people did not comply with discovery, where the people did anything unethical. You've already found, you used the words, it was not inadvertent. Not inadvertent, Your Honor, means they lied and they intentionally did not give us what they
I
were
don't agree with that. That's not, doesn't mean he lied.
Your Honor, not inadvertent.
Don't argue with me. I don't think it means he lied. I just said it was not inadvertent. That's the extent of my finding. It was not inadvertent. I'm not going to debate with you whether they were or were not lying. I don't believe it was a lie. I want to give the court reporter a break, and we'll take a break until 3. Wait.
Judge, I have to just respond to a few things, but there's a record here. One thing, I don't want to upset the court, so we can do it.
You're not going to upset me.
No, I'll be quick. I don't want to be perfect, I'm sorry. But there were some things that were said that were just wrong. First of all, they called our witnesses liars in their summation. So I'm calling their witnesses a liar, which he admitted to being, by the way. So, I mean, if our witnesses are lying, and I put them up there, obviously they're saying we came up with this Tottenham story. So they're saying, I object, and they say I'm supporting her. That's what they're saying, number one. Number two, I can't say that they want to win at all costs. That's an argument. I think I can say that. I don't think that's an improper argument. If you say it is, I won't say it again. But the other thing, Your Honor, I didn't argue that that wasn't a statement. I said it's not a sworn statement of 12B, and it's not a recorded statement. I said it's a summary. I'm accurately describing it. It is a summary. I'm just going through what I said. They disparaged our entire defense, mocked it. So I'm giving them a little bit back. I don't think I'm doing something.
You want to interrupt him? He didn't interrupt you?
And the thing that he said, though, first of all, I disagree. I think one fact of relevance would be a reasonable doubt. If the jury finds he's incredible on one thing of importance, like the shell casings, that's a reasonable doubt. If they so choose, it's up to them to decide what a reasonable doubt is. That could cause them to find not guilty. That's up to them. But it certainly is an argument that can be made. They can say, no, it's not a reasonable doubt. But I can make that argument.
It's very common.
I know. But the last thing, I think Mr. Lewin's hearing failed for a second. Because the one thing, because I know he said he has an issue with it, the one thing I never said was they could have called Haji. I wouldn't do that. I didn't say that. They could check the record. What I said was they spoke to him that morning. They had a recording of Haji. That was brought out to Lewin. I said, if Lewin was inconsistent with Haji, we would have heard the tape. I didn't say they could have called Haji. If I can show you where I said that, I would never have said that, because we could have called Haji. He wasn't willing to come. So I never said that. I just simply said what was on the record.
And if it was said, Mr. Lewin can address it tomorrow. If it wasn't said, then there's nothing to address. All right, we're off the record. I want to give Kathy a break. So can you find